Honorable Attorney Jervil Jinky Beatrix R. Luistro, Honorable Jonathan Keith T. Flores, Honorable Lordan G. Suwan, Honorable Bienvenido M. Abante Jr., Honorable Jude A. Asidre. For the authors of the bills, Representative Attorney Jervil Jinky Beatrix R. Luistro, Representative Jonathan Keith T. Flores, Representative Sherlyn L. Bañas Nograles, and Representative Nelson S. Legacion. And for our resource persons, from the Supreme Court of the Philippines, Deputy Court Administrator, Honorable Lilian C. Baribalco, from the Department of Justice, Chief State Counsel Dennis Arvin L. Chan, State Counsel Jenny Rose G. Avellano Catalo, Senior State Counsel Rosario Elena Laborte Cuevas, from the National Prosecution Office and the President of the State Prosecution Attorneys Association, Inc., Senior Assistant State Prosecutor Mary Jane W. Sitat, from the Prosecutors League of the Philippines, Incorporated, City Prosecutor Armando H. Cavalida, City Prosecutor Sinforoso T. Roque Jr. From the Department of Budget and Management, Attorney Tennessee Ann L. Mengulio. From the Department of Foreign Affairs, Mr. Paulo V. Saret, Executive Director, Office of the Treaties and Legal Affairs. From the Office of the Solicitor General, Assistant Solicitor General George O. Ortha II, and Associate Solicitor Elaine D. Hilario Tu. From the Bureau of Immigration, Attorney Emmanuel Anthony L. Vera Jr. From the Public Attorney's Office, Attorney Noliver F. Barido and Attorney Maria Angela A. Hernandez. From the National Bureau of Investigation, Supervising Agent Filipinas S. Astrero and Attorney Jimboy D. Aranas. From the Government Service Insurance System, Attorney Giovanni Lynn Kikoy Marin. From the National Security Council, Attorney Aisel D. Pangan. From the Bureau of Corrections, Deputy Director General for Administration, Assistant Secretary Al I. Pereras. From the Integrated Bar of the Philippines, President of the Integrated Bar of the Philippines, Attorney Alan G. Panolong, Attorney Patrick M. Velez, and Attorney Manuel Joseph Ibanez. And from the City Chief Prosecutors Association, Attorney Erwin Maraya. That's all, Your Honor.
We now proceed to the first item in our agenda, the initial consideration of 9 bills on the grant of hazard pay to public prosecutors. Now, as the author of House Bill 2341, one of the bills supporting the same hazard pay for public prosecutors, the Chair is adopting the explanatory note as her sponsorship speech. As stated earlier, I would just like to emphasize that all the bills in this 20th Congress are substantially similar to House Bill number 11545, the one which reached the third and the final reading during the 19th Congress. Since this bill has been thoroughly scrutinized by the committee last Congress, we are hoping that we can easily come up with a substitute measure incorporating any new proposal from the authors of the rest of the bills or from the stakeholders or even our resource persons. The COMSEC is now directed to read the title of the bills.
House Bill number 1799, an act granting hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned cases and appropriating funds therefore, filed by Representatives Rufus B. Rodriguez and Maximo B. Rodriguez Jr. House Bill number 2341, an act granting hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned cases and appropriating funds therefore, filed by Representative Attorney Jervil Jinky Beatrix R. Luistro. House Bill Number 2664, an act granting hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned cases and appropriating funds therefore, filed by Representatives Ferdinand Martin G. Romualdez, Yeda Marie K. Romualdez, Andrew Julian K. Romualdez, and Jude A. Asidre. House Bill Number 3707, an act granting hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned cases and appropriating funds therefore, filed by Representative Isabel Maria J. Zamora. House Bill Number 4028, an act granting hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned cases and appropriating funds therefore, filed by Representative Attorney Miro S. Kimbo. House Bill Number 4450, an act amending Republic Act Number 10071, otherwise known as the Prosecution Service Act of 2010, to provide hazard pay and security measures for public prosecutors, filed by Representative Marcelino Marcy R. Teodoro. House Bill Number 4748, an act mandating the grant of hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned case and appropriating funds therefore, filed by Representative Carmelo G. Lasatin Jr. House Bill Number 4832, an act granting hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned cases and appropriating funds therefore, filed by Representative Jonathan Keith T. Flores. And House Bill Number 5568, an act granting hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned cases and appropriating funds therefore, filed by Representative Sherlyn L. Banyas Nograles. That's all, Your Honor.
At this point, we will be recognizing the sponsors of these legislative measures. To begin with, we recognize the Honorable Congressman Rufus B. Rodriguez and Congressman Maximo B. Rodriguez Jr. for the sponsorship speech in support of House Bill Number 1799.
Madam Chair,
The Honorable Vice Chair Flores is recognized.
Representative Rufus Rodriguez, Madam Chair, is also holding a committee hearing for the Committee on Constitutional Amendments. And for his behalf, Madam Chair, for the House Bill Number 1799, may I move that the explanatory note attached to the bill be considered as the sponsorship speech for the said bill.
There is a motion to adopt the explanatory note as a sponsorship speech of the sponsors of this bill. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the explanatory note is hereby adopted as the sponsorship speech of the authors, Representatives Rufus Rodriguez and Maximo B. Rodriguez Jr. For House Bill Number 2664, we recognize the Honorable Congressman Ferdinand Martin G. Romualdez, Yeda Marie K. Romualdez, Andrew Julian K. Romualdez, and Jude A. Asidre. The Honorable Jude Asidre is recognized.
Madam Chair, dear colleagues, members of this committee, and resource persons, it's my honor to sponsor before this committee House Bill 2664, an act granting hazard pay to public prosecutors exposed to hazardous situations and performing hazardous duties related to assigned cases and appropriating funds therefore. I ask, Madam Chair, that the explanatory note attached to the same measure be adopted as our sponsorship speech. But I pointing out, Madam Chairman, that this measure was filed in the 19th Congress and was approved on third and final reading by the House of Representatives, and we hope that we can speedily, look forward to a speedy approval of this measure. Thank you, Madam Chair.
Thank you, Honorable Asidre. There is a motion to adopt the explanatory note as the sponsorship speeches of the authors. Do I hear a second? The same has
Second.
been seconded. Is there any objection? Hearing none, the explanatory note is hereby adopted as the sponsorship speeches of the principal author. The rest of the manifestation of the Honorable Asidre is noted by the committee. Now we proceed to House Bill number 3707. The Honorable Congresswoman Isabel Maria J. Zamora is recognized.
Madam Chair.
The Honorable Asidre is recognized.
On behalf of the Honorable Isabel Maria Zamora, I move that the sponsorships, the explanatory note to House Bill 3707 be considered as the sponsorship speech for this measure.
There is a motion to adopt the explanatory note of HB 3707.
Madam Chair, can we include also the explanatory note of other authors that are not actually here today as far as the motion is concerned?
The Honorable Abante, we shall be calling one by one the legislative measures to give opportunity to the authors or their respective representatives for today's hearing to give their respective manifestation on this legislative measure.
Yeah, but they're not here, Madam Chair.
Some are here, Honorable Abante.
All right.
There is a motion to adopt the explanatory note of House Bill 3707, a sponsorship speech of the Honorable Zamora. Do I hear a second?
Second.
The same has been seconded. Is there any objection? Hearing none. The explanatory note of HB 3707 is hereby adopted as the sponsorship speech. For HB 4208, the Honorable Congressman Attorney Miro S. Kimbo is recognized.
Madam Chair.
The Honorable Vice Chair Flores is recognized.
For House Bill number 4028 and for and in behalf of Representative Miro Esquimbo, may I move that the explanatory note attached to the bill be considered as the sponsorship speech, Madam Chair.
There is a motion to adopt the explanatory note of HB 4208 as the sponsorship speech of the Honorable Kimbo. Do I hear a second? Is there any objection? Hearing none, the explanatory note of HB 4208 is adopted as the sponsorship speech of the Honorable Kimbo. We proceed to HB 4450. The Honorable Congressman Marcelino Marcy R. Chodoro is recognized.
Madam Chair.
The Honorable Congressman Asidre is recognized.
Madam Chair, on behalf of the author, I move that the explanatory note to House Bill 4450 be considered as sponsorship speech for the same measure.
There is a motion to adopt the explanatory note of HB 4450, a sponsorship speech of the Honorable Chodoro. Do I hear a second? Is there any objection? Hearing none. The explanatory note of HB 4450 is hereby adopted as the sponsorship speech of the Honorable Marcy Chodoro. Moving forward, House Bill 4748, the Honorable Representative Carmelo H. Lazatin Jr. is recognized. The Honorable Congressman Asidre is recognized.
Madam Chair, I move that the explanatory note, on behalf of the author, I move that the explanatory note to House Bill 4748 be considered a sponsorship speech for the same measure.
There is a similar motion to adopt the explanatory note as the sponsorship speech of the author. Is there any second? Is there any objection? Hearing none, the explanatory note of House Bill number 4748 is hereby adopted as the sponsorship speech of the Honorable Lazatin Jr. As second to the last, House Bill number 4832, the Honorable Congressman Vice Chair Jonathan Keith T. Flores is recognized.
Thank you, Madam Chair. For House Bill number 4832, Madam Chair, may I move that the explanatory note attached to the same bill be considered as a sponsorship speech, Madam Chair. But I would like to take note, Madam Chair, that I am also very much willing to make amendments specifically as to the amount of the hazard pay, Madam Chair, considering that there have been inflation and other changes in the prices of goods, Madam Chair.
That is very much welcome to the prosecutors. There is a motion to adopt the explanatory note of 4832 as the sponsorship speech of the Honorable Flores. Do I hear a second? The same has been seconded. Is there any objection? The explanatory note of HB 4832 is hereby adopted as his sponsorship speech. All other manifestations, particularly with respect to amending the amount to increase the amount of the hazard pay, is noted by the committee. As last legislative measure on the matter, House Bill number 5568, The Honorable Congresswoman Sherlyn L. Bañas Nograles is hereby recognized.
Thank you, Madam Chair. Madam Chair, I move that the explanatory note of House Bill 5568 be adopted as by sponsorship speech. And I also submit, I would, with respect also to the amount of the hazard pay, I submit eventually to whatever would be the pleasure of the body.
The prosecutors are smiling. There is a motion to adopt the explanatory note of House Bill 5568 as the sponsorship speech of the Honorable Bañas Nograles. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the explanatory note of 5568 is hereby adopted as the sponsorship speech of the author. Moving forward, we now call the COMSEC to call our resource persons regarding their comment, manifestations, insights with respect to this legislative measure. COMSEC, please.
Thank you, Your Honor. From the National Prosecution Service and the President of the State Prosecution Attorneys Association, Inc., Senior Assistant State Prosecutor Mary Jane W. Sitat.
Good morning, Your Honors. First of all, we would like to thank all of you for sponsoring the hazard pay bills. Today, we appear before you as one with the Prosecutors League of the Philippines as well as the Chief Prosecutors of the Philippines. But for today's presentation, we would like to give the floor to our President, the President of the Prosecutors League of the Philippines. We have come up with a presentation so that the honorable body could very well understand where we're coming from and why we need this hazard pay, Your Honor.
May we know, Prosecutor Sitat, how long will the presentation take?
Very short only, Your Honor.
Will it take 5 minutes or 3 minutes?
Good morning, Your Honor, Madam Chair. It is practically less, Your Honor, because it's only around 11 slides.
So
And-
it's less than 3 minutes?
Yes, Your Honor.
We have stated earlier that we had thorough deliberation already on this legislative measure during the 19th Congress, and that is why we're encouraging all the members, including the resource persons, that we come up with a proper substitute bill at the soonest possible time. After all, it seems that everybody is supporting this hazard pay for the prosecutors. So I hope we can finish with the presentation within the less than 3 minutes mentioned by our resource person. Prosecutor Cavalida, the President of the Prosecutors League of the Philippines Incorporated, is recognized. Please proceed, sir.
Okay. Good morning, Madam Chair, Your Honors. I am City Prosecutor Armando Cavalida, the President of the Prosecutors League of the Philippines Incorporated. Now, Your Honors, at the outset, may I, on behalf of the PLP as well as the DOJ, NPS in particular, may extend our heartfelt gratitude and appreciation for the committee for taking this bill of ours. Though admittedly, as what had been said by the Madam Chair, there already was a bill, House Bill 11545, that has been approved, and we hope that these bills, practically they are the same, only a minor differences, that this would be likewise approved easily, Your Honors. Now, our presentation will tackle only, Your Honor, on the reasons why the prosecutors practically are asking for this hazard pay bill. As we have known, and as a matter of fact, as stated in the explanatory notes of the sponsors for these bills, there are no less, as of now, 29 incidents involving both the killing as well as our ambushes over our prosecutors, which are practically related to the work. Aside from that, we have some prosecutors practically asking mortuary benefits from the PLP or even reimbursements by reason of the pressures of the work that had, in a way, make them suffer that much, that some even went to the point of suffering strokes, going to death. Now, Your Honors, as I have said, there are no less than 29 prosecutors that were ambushed, and 23 of them died, while 6, some suffered injuries, and only 1 did not, by reason of some fortuitous event also, or it was pure luck. Now, the last of which, Your Honor, was way back, 20, that was December 31, 2021, in the person of ACP Edelberto Mendoza. And worse, in this situation, he was just walking and, in front of his house, taking an exercise in the morning, and unfortunately, a gunman went to him and shot his head in Batangas, in Cavite. Now, the amount really that has been asked by the prosecutors in this case, if we have to go back to the 5,000 that has been included in the bills, Your Honor, it is not really that much, because it will have only a total of around 227 million annually, Your Honor. But if, say, for example, with the statement of the Honorable Kit Flores that is open to an amendment, if we can be given the chance of a 5%, Your Honor, of the salaries, there would only be a little difference, Your Honor, and that would only be around 900,000 plus at 5% annually.
5% increase annually.
A 5% based on the salaries of the
I see.
prosecutors, Your Honor, because in the prosecution service, there is, of course, the ladderized, the difference in position. We have the assistant city prosecutors, or at the lowest would be the prosecution attorneys. Then we have the assistant city prosecutors. Then we have the senior assistant city prosecutors. Then the CPs or PPs and regional prosecutors.
So how is this 5,000 hazard pay, which is originally the one being requested in the legislative measure, different from the 5% which you mentioned?
During the hearing on the Committee of Appropriations, then, Your Honor, it was agreed and proposed, as proposed and agreed, it would be across the board. That is 5,000 pesos. So in other words, it has no difference at all as to the kind of positions and ranks of the prosecutors. Now, if and when an amendment could be done or be approved by the Honorable Committee, this would show the ladderized, or it would depend on the positions of the, because, Your Honor, the reason for which, as per our prosecutors, the fact remains that, yes, the higher you are in the position, the more the number of hazard that you face. Because the reviewing, the investigating prosecutor or the inquest prosecutor, his resolution will be reviewed. So it is the reviewing who will always sign. And then the approving would be the head of the office. So if there are so many, like, say, for example, Your Honor, in cases of drugs or 9165, there are several cases of 9165 that has been filed, and several persons involved. And of course, the investigating as well as the reviewing and the city prosecutors would sign the same.
Going back to the amount, so you are saying
Madam
that if
Chair,
it is not,
Madam Chair.
let me finish my question first, Honorable Abante. If not 5,000 hazard pay, you are suggesting also 5% of the basic salary. So it's an alternative.
Yes, Your Honors. If, as an alternative only, Your
Okay.
Honor.
The Honorable Abante is very much recognized.
Madam Chair, am I made to understand that aside from the 5,000 across the board, you would like to propose that we add 5%, or we actually discard the 5,000 and just go with the 5%?
Before the response of the Prosecutors League of the Philippines, we would like to acknowledge the presence of the Honorable Congressman Henry F. Waminal Jr. from Ascenso Pinoy Party List, and of course, the Honorable Attorney J.P. Padiernos from Galing sa Puso Party List. Thank you for coming. You may proceed, Prosecutor Cavalida.
Good morning, Honorable Abante. Yeah, so it's not really in addition thereto, but it is in alternative, Your Honor. Because we are really in hoping that this bill be adopted, taking into a fact that it has already been, or there was already a bill approved under HB 11545, which states only the amount of 5,000 pesos. But however, since there was a statement that maybe the honorable committee would be open to an alternative or an amendment to the amount, then we suggest only 5% of the basic salary of the prosecutors, Your Honor.
So, Madam Chair, ang ano ko dito is that wag na nating pag-usapan yung 5,000 a month, but go with the ladder rights increase of 5%.
Yes, Your Honor, if we give it a chance.
I go with the logic of the prosecutor, Madam Chair. So, kinakailangan din ako sa kabilang ngayon, so I have to go. But I would like to even make a motion now that we adopt the ladder rights proposal of Prosecutor Armando Cabellida.
Thank you very much, sir.
Chair takes note of the motion of the Honorable Chair Abante of the Committee on Human Rights. No, naging CHR na tuloy. The Chair will take action on the motion of the Honorable Abante in due time after all the resource persons are done with their respective manifestations and comments on this legislative measure. This is not yet the interpellation for the guidance of the committee members. We're still on the manifestation and comments of our resource persons. We will have the interpellation after the presentation of all the resource persons. Nonetheless, it is clear already that we have two alternatives now being presented by the Prosecutors League of the Philippines, either the 5% hazard pay, 5,000 hazard pay as originally requested from the previous Congresses, or the 5% ladderized, 5% of the basic pay as ladderized mode of determining the hazard pay of the prosecutors. It's an or and not an and.
Yes, Madam Chair.
Any other concern, Honorable Abante?
Madam Chair, I have to really go. But
I hope you will come back.
I would like to reiterate my motion. I hope that it will not be forgotten.
It is duly noted, Honorable Chair Abante. He has his own committee hearing right now. We are multitasking. May we request the Prosecutor Cabellida to proceed?
Well, that would be the end, Your Honors,
Okay.
Madam Chair, considering that the others I will be tackling only on the specific amounts, but that's already been one way or another approved.
Just
raised.
for the clarity of the alternatives that you have presented, if we will be adopting the 5% of the basic salary as a ladderized mode of determining the hazard pay, how much will be the lowest amount of hazard pay?
Paano natin i-open? Well, the lowest amount, Madam Chair, would be 5,586.35.
So this is
For-
higher than the 5,000 originally requested.
Yes, a little higher, Your Honor.
And you made mention earlier also of the aggregate amount, the total amount if we adopt the 5% of the basic. How much is that
The
again?
total amount, Your Honor, would be 337,955,000.
So it's a difference of
127.
110 million.
Yes, Your Honor.
Okay. Okay. So you're done with your presentation?
Yes, Madam
Okay.
Chair. Thank you, Your Honors.
Next, we will be proceeding to the, so that is for National Prosecution Service and the Chief Prosecutors and the Prosecutors League of the Philippines already. Comsec, kindly call our next resource person.
From the Chief Prosecutors Association, President Attorney Irwin A. Maraya.
Good morning, Madam Chair. Good morning, Your Honors. On behalf of the Chief Prosecutors Association, we are happy that we were invited and that the committee is taking up our cause. And my colleagues here have already elucidated on other things that we would want included in the bill, Your Honor. And we have nothing more to add insofar as the process is concerned. Thank you so much.
May the chair ask, where are you assigned right now?
I'm currently Regional Prosecutor of Region 8, Your Honor.
Wow, congratulations, Chief.
Thank you so much.
How do
Madam
I
Chair,
address you, Chief Prosecutor?
Erwin's good.
That's different from Chief State Prosecutor. That's different, right? Regional Prosecutor Erwin Maraya. It's nice to see you
Yes.
again.
Same here
Okay.
po.
Now we proceed to our next resource person.
From the Integrated Bar of the Philippines, National President Attorney Alan G. Panolong.
Madam Chair,
Attorney
Members.
Panolong is recognized.
yes, Madam Chair, members of this honorable committee and fellow resource persons, good morning. As far as the Integrated Bar of the Philippines, we fully support this measure because, as we all know, basically, the life of a lawyer is really risky. More so for lawyers who are in the prosecution service, who are dealing with the accused criminals from time to time. So with that, Madam Chair, we fully support the measure being proposed before this honorable committee. Thank you.
Yes, in line with that, I just wish to share with the committee that I had the dialogue, the chair had the dialogue with Prosecutor General Fadulion yesterday regarding this legislative measure, and he's of course very much committed to support and shepherd this hazard pay for all the prosecutors. And that was one question which I raised to him: what is the difference between the hazard which is being faced by prosecutors vis-a-vis the public attorney's office and vis-a-vis the private lawyers and even vis-a-vis the people in the judiciary? And he has one clear answer, no? As distinguished from the situation of the people in the judiciary, the prosecutors is aligned only with one side, and that is the side of the complainant. So you are the one going against the people who can be imprisoned if you will be successful in your prosecution. And of course, it is a common knowledge, the people who are accused, the people who are facing these cases are normally the people who are being alleged of the crime of murder and other criminalities. So they have the propensity of committing violence or danger against the people who might be behind their prosecution or even their imprisonment or conviction. So, to proceed, COMSEC, let us acknowledge our next resource person.
From the Department of Budget and Management, Attorney Tennessee Ann L. Mengulio.
The prosecutors are invited to listen to our DBM.
Good morning, Madam Chair, Your Honors. We understand the intention of the proposed measures. This is for our prosecutors who are exposed to great dangers and hazardous situations in the administration of justice. However, as part of our judicious management of government resources, we note that first, the initial proposal of 5% hazard pay monthly, this will require an additional of 204 million.
It will be 110 million
That is for the 5% ladder
for the
rise.
5%.
Yes, Madam Chair. So,
How about in the previous Congress? How much budgetary requirement does it involve?
for 204 million, Madam Chair. For the initial proposal, Madam Chair, in the previous Congress, 204,300,000 pesos.
204 million, but according to our resource persons from the PROSEC, it's 227 million if we will be adopting the 5,000 hazard pay per prosecutor. So
Yes, Madam Chair.
that's a difference of 19 million. Is that correct?
I'm sorry, Madam Chair. The 204 million is based on the current rate. So if the
Is that for the 5,000 hazard pay or for
Yes.
the 5% hazard pay?
the 204 million, Madam Chair, is for the 5,000 hazard pay.
Okay.
Whereas for the proposed 5% of the salary po, that would be around 337 million, Madam
Okay.
Chair.
Okay. So what is the position of the DBM?
Madam Chair, if the hazard pay will be granted to our honorable prosecutors, we just want to note that this will also encourage or trigger the request of other government agencies who have government lawyers, including the Public Attorney's Office, who are also exposed to similar situations. And also, with the huge amount required for this, Madam Chair, this will put us into a tighter situation in our fiscal position, Madam Chair.
I hope that the DBM understand that the situation of the prosecutors are distinct from the rest of the government lawyers. Sabi ko nga, even if we compare it with the judiciary, at least the judiciary has the opportunity to weigh between two sides which argument or which cause will be sustained by the court. But with the prosecutors, they have only one side to stand on, and that is the side of the complainant, the side which is against the accused, the side which causes the people who are alleged to have committed the crime to go to prison. And if we even compare that with PAW, the PAW are the ones defending the accused. So, no way that this accused will have ill motive or bad intentions against PAW lawyers, with all due respect to PAW. But that's the way I see it. I was not a prosecutor before. I used to be a state counsel, Fiscal Maraya. But I do understand where the prosecutors are coming from. As a matter of fact, based on the incidents presented by Prosecutor Cavalida, all of them are prosecutors who were killed or injured by reason of their work. That is occupational hazard, the way we understand it. And I don't think that the situation of the prosecutors are comparable with the other lawyers in the government service. That is just a manifestation. Of course, you can always take your position as the Department of Budget and Management. But may we request for your comment about the 204 million? Is this okay with you, the 5,000 hazard pay? Because you mentioned about the previous bill, the previous
Yes.
Congress.
Yes, Madam Chair.
And I wish to remind you that this was approved on the third and final reading, which means that it passed the Committee on Appropriations already of the previous Congress, where budgetary requirement is amply deliberated upon. So what's your position about this 204 million?
Madam Chair, we recommend the further study considering the fiscal implications of the proposed benefit. However, we ultimately defer to the wisdom of Congress, Madam Chair.
I wish to believe that the position of the DBM during the previous Congress is an official act of the DBM. And I do not understand why it should be modified or even recalled on the present Congress. Well, that is just a manifestation again. Nonetheless, are there any other comments you wish to manifest?
That would be all, Madam Chair.
Okay.
Thank you po.
So both 204 and 337 million will be studied pa by the DBM.
Can I add another
Yes.
comment, Madam Chair?
Please do.
Yes, Madam Chair, because we are also considering there will be the second tranche of our salaries next year. So there will also be an increase in our PS cost.
Where is this second tranche of increase of salary for prosecutors?
For
For
government
all government
employees. Yes, Madam Chair.
employees. But I am certain that this second tranche has been foreseen planned and studied by the DBM long time ago and has been provided for also even before the scheduled second tranche, no? So I don't see why that second tranche will affect in any way this hazard pay of the prosecutors, especially considering that this passed already the Committee on Appropriations in the previous Congress, where the DBM amply participated. Thank you.
Thank you, Madam Chair.
Next resource person. Okay. So that would be all. The floor is now open for interpellation of the members or authors of the legislative measure.
Madam Chair,
The Honorable Asidre is recognized.
just a manifestation, Madam Chair. I hope that we do not take this measure as something that we are trying to add up to the compensation of our prosecutors, even though it may appear as it is. But rather we should consider this as an investment in our prosecutorial service. Who will benefit from this will not necessarily be our prosecutors, but the entire justice system in the country. And I think when our prosecutors are able to carry their duties without fear, or they have greater confidence in their safety and security, then it is justice that is best served, and it is the welfare of the people that we are trying to ensure. That's why, Madam Chair, I joined the motion of the Honorable Abante earlier that if
We adopt the ladderized.
the committee so decides to adopt the ladderized scheme wherein the hazard pay will be paid at 5% of the basic salary, I believe. So I move, Madam Chair.
There are two sponsors now of the pending motion to adopt the ladderized system of hazard pay of prosecutors. For the record, any other question or comment from our committee members?
Madam Chair,
The Honorable Nograles is recognized.
just my take on the matter. I understand that the assignment of cases is through raffle. So all the prosecutors are equally exposed to hazard. So I believe, Madam Chair, that it will be better that it's across the board. But we can maybe 5,000 is a bit small. We can increase it a bit. Kasi sa ngayon, with the inflation, masyado namang maliit yung 5,000. But anyway, that's just my take, Madam Chair. I would eventually submit to whatever would be the pleasure of the majority.
Can you give us any idea about the increased amount that you are proposing for the hazard pay, Honorable Nograles? For the record?
As of the moment, Madam, I cannot give an exact figure. But
Any
I agree
amount?
that
Higher than 5,000.
maybe we'll consult the DBM, Madam Chair, if what will be their proposal based on the budget na kaya natin.
The DBM at the moment is neither willing for the 5,000 nor the 5%.
Maybe
Okay, just for the record, the Honorable Nograles is suggesting that the hazard pay should be across the board, meaning a uniform amount to be given to all the prosecutors because all of them are equally exposed to risk. That is her position. She's in fact suggesting for an increased amount, which the committee may determine later. Any other comment, manifestation from the committee members? Before we proceed, we would like to acknowledge the presence of the Honorable Congressman Jose Manuel Tadeo Chel I. Jokno from Akbayan Party List. Thank you, Kong, for coming. Any other comment or manifestation from the members? Okay, hearing none, then let's tackle one by one. No? There are three alternatives which are now presented before the committee. One is the original 5,000 hazard pay. Second is the ladderized system, which is 5% of the basic pay. The lowest hazard pay with that system would be 5,586. That is for the for the entry level, perhaps, of prosecutors. And the third will be the increased amount of hazard pay flat rate, the one suggested by the Honorable Nograles. Meantime, the hearing is suspended. Pasuyo po ako sa mga prosecutors dito. That no members are willing to raise further interpellations or comments on the matter. Therefore, the committee is now ready to hear the proper motion.
Madam Chair.
The Honorable Asidre is recognized.
Madam Chair, I move that we consolidate and approve House Bill 1799, 2341, 2664, 3707, 4028, 4450, 4748, 4832, 5568, together with its accompanying committee report subject to style and form. So I move, Madam Chair.
There is a motion to consolidate and approve the aforementioned House bills, including its corresponding committee report, subject to form and style. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion to consolidate and approve the aforementioned bills on hazard pay of prosecutors, including its corresponding committee report, subject to form and style, is hereby approved. Congratulations to our prosecutors. Just for the guidance of everyone, there were three alternatives which were presented. One is the original 5,000 hazard pay. Second is the ladderized 5% of the basic pay. And the third is the increased hazard pay flat rate. This matters appropriately falls within the jurisdiction of the APRO committee, to which the substitute bill will be transmitted upon its approval. So the committee opted to defer the discussion and resolution of the mode which will be adopted in determining the hazard pay, the amount of hazard pay. Nonetheless, we are aligned that the committee members do all support the provision for hazard pay for all our prosecutors. With that, congratulations to all our prosecutors.
May meeting na ako sa DSWD.
Thank you, boss. Thank you, boss. To give time to the resource persons who were invited for the hazard pay,
Madam Chair,
the Honorable Padiernos is recognized.
Madam Chair, may I move to include all those present here to be co-authors of this bill?
Everybody wants to become author of this bill.
second the motion.
There is a motion to include all the present members as co-authors of the hazard pay law for all our public prosecutors. The same has been seconded. Is there any objection? Hearing none, the motion to include all present members as co-authors of this bill is hereby granted. To give time to the resource persons attending for the purpose of this hazard pay only to excuse themselves, the committee hearing is suspended. We will resume in 1 minute. All resource persons for the succeeding items are requested to stay. May we request all the remaining resource persons to please occupy the center seats? We now proceed to the next item in our agenda. As the author of House Bill 2342, I am adopting the explanatory note as my sponsorship speech. I wish to stress again that the bills for the strengthening of the office of the Chief State Counsel have been approved by the committee in the 19th Congress, and the substitute bill was transmitted to the Committee on Appropriations. Since this bill has likewise been thoroughly discussed by the committee during the last Congress, I hope that we can easily come up with a substitute measure incorporating any new proposal from the authors of the rest of the bills or from the stakeholders. The committee secretariat is directed to read the title of the bills.
Thank you, Your Honor. House Bill number 2342, an act strengthening the legal staff of the Department of Justice, renaming it as the Office of the Chief State Counsel, redefining, expanding, rationalizing, and further professionalizing its organization and appropriating funds therefore, filed by Representative Attorney Jervil Jinky Beatrix R. Luistro. House Bill number 3575, an act strengthening the legal staff of the Department of Justice, renaming it as the Office of the Chief State Counsel, redefining, expanding, rationalizing, and further professionalizing its organization and appropriating funds therefore, filed by Representative Isabel Maria J. Zamora. House Bill Number 3951, an act strengthening the legal staff of the Department of Justice, renaming it as the Office of the Chief State Counsel, redefining, expanding, rationalizing, and further professionalizing its organization and appropriating funds therefore, filed by Senior Deputy Speaker Ferdinand L. Hernandez. House Bill Number 4279, an act strengthening the legal staff of the Department of Justice, renaming it as the Office of the Chief State Counsel, redefining, expanding, rationalizing, and further professionalizing its organization and appropriating funds therefore, filed by Representative Attorney J.P. Padiernos. House Bill Number 4376, an act strengthening the legal staff of the Department of Justice, renaming it as the Office of the Chief State Counsel, redefining, expanding, rationalizing, and further professionalizing its organization, and appropriating funds therefore, filed by Representatives Rufus B. Rodriguez and Maximo B. Rodriguez Jr. And finally, House Bill Number 5171, an act strengthening the legal staff of the Department of Justice, renaming it as the Office of the Chief State Counsel, redefining, expanding, rationalizing, and further professionalizing its organization and appropriating funds therefore, filed by Representatives Henry Indy F. Waminal and Sanja Fernando Ando F. Waminal. That's all, Your Honor.
With that, we are proceeding to the sponsorship speeches of our principal authors. To begin with, we recognize the Honorable Congresswoman Isabel Maria J. Zamora for the sponsorship speech of House Bill Number 3575.
Madam Chair,
The Honorable Padiernos is recognized.
Madam Chair, I move that the explanatory note of House Bill Number 3575 be adopted as Representative Isabel Maria J. Zamora's sponsorship speech.
There is a motion for the adoption of the explanatory note of HB 3575, a sponsorship speech of the Honorable Zamora. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the explanatory note of HB 3575 is hereby adopted as the sponsorship speech of the Honorable Zamora. Moving on, House Bill Number 3951, the Honorable Senior Deputy Speaker Ferdinand L. Hernandez is hereby recognized.
Madam Chair, I was informed that our Senior Deputy Speaker, Representative Ferdinand L. Hernandez, not be able to make it today for a prior commitment, but having filed a similar bill, I was asked to deliver his sponsorship speech.
The Honorable Waminal is recognized to sponsor the bill of SDS Ferdinand L. Hernandez along with his own bill. You may proceed, Kong.
Okay, thank you, Madam Chair. For House Bill 3951, for the sponsorship speech of our Senior Deputy Speaker, Honorable Chairperson and Vice Persons of the Committee, distinguished members, colleagues from the Department of Justice, Secretariat and Congressional Staff, friends from the media, magandang umaga po sa ating lahat. In this period of profound transition, where the world grows more complex and the problems facing nations grow sharper and less forgiving, our country stands at a defining moment. The administration's call for Bagong Pilipinas is not a banner to wave, nor a slogan to repeat. It is a challenge. A challenge to build institutions that are strong enough, modern enough, and prepared enough to meet the demands of a republic that can no longer afford the weaknesses of yesterday. And as we answer that challenge, we must confront a truth within our own institutions, particularly within the Department of Justice. For decades, the DOJ's legal staff has carried out its mission with quiet persistence. The law once envisioned it as an office devoted to legal opinions and advisory work. But the world has changed, and with it, the responsibilities of this office have multiplied in ways no one could have predicted. Today, it is the nerve center of our international legal cooperation, extradition, mutual legal assistance, transfer of sentenced persons, treaty and trade agreement negotiations, refugee and statelessness frameworks, and the delicate legal architecture of our engagements with the global community. It is the place where legal questions are settled, immigration determinations reviewed, and disputes between agencies are resolved. It is the DOJ's backbone, steady, unseen, and indispensable. It is yet, despite this evolution in responsibility, the structure that supports the office remains frozen in another time. The mandate has expanded, the machinery has not. The demands have grown, the resources have stood still. That is the problem before us, and that is why we are here today. Congress has the authority and the duty to close this gap. This measure, filed and refiled across Congresses, offers a clear and disciplined path forward. Honorable colleagues, it is time. Let us support House Bill 3951, titled An Act Strengthening the Legal Staff of the Department of Justice, renaming it as the Office of the Chief State Counsel, redefining, expanding, rationalizing, and further professionalizing its organization and appropriating funds therefore. HB 3951 strengthens, rationalizes, and modernizes the Office of the Chief State Counsel. It expands its divisions, upgrades its positions, aligns its compensation and retirement benefits with the judiciary, and builds a professional environment capable of attracting and retaining legal minds this nation requires. This is not merely an administrative fix. This is an act of nation building. If we expect a justice system that protects our national interests at home and abroad, then we must empower the very office that defends us on both fronts. And so today, we have a choice. We can allow an outdated structure to strain under 21st century burdens, or we can give this institution the tools it needs to meet the moment. The President's call for Bagong Pilipinas is clear. Build the institutions worthy of the future we seek. Let us act decisively, urgently, and with purpose. Because when the rule of law is strengthened, the Republic stands taller. And when the Republic stands taller, the people stand with it. May God bless our work today, and may we choose the path that strengthens the nation. Maraming salamat po. And Madam Chair, if I may proceed for House Bill 5171.
Before you proceed, Honorable Waminal, the committee notes the sponsorship speech of the Honorable Senior Deputy Speaker Ferdinand L. Hernandez in support of House Bill number 3951. With the indulgence of the Honorable Padiernos and the Honorable Rufus Rodriguez and Maximo Rodriguez, we shall allow the Honorable Waminal to finish with his own bill, in particular House Bill number 5171. You may proceed, Honorable Waminal.
Thank you, Madam Chair. And once again, good morning to everyone present at this hearing today. For House Bill 5171, Madam Chair, just ask that our explanatory note be adopted as our sponsorship speech. And may we just have a few more minutes to add further manifestations, Madam Chair. Currently, the legal staff is tasked with providing legal opinions, not only to the DOJ as Attorney General, but also to our GOCCs and the state as a whole, especially in the realm of treaty negotiations and interpretation. And when there are varying legal opinions owing to the constant change in the persons of the state councils, it can erode the trustworthiness of our institutions and the state as a whole. Hence the need to clarify and confirm the permanent character of the appointments to the office of the State Council. And additionally, Madam Chair, the State Councils play just as important role to the executive justice system as their counterparts in the state prosecutorial arm. So they are deserving, we believe, of at least similar pay and benefits, Madam Chair. And with that, we ask and pray for the support of our dear colleagues in the passage of this measure. Thank you very much, Madam Chair.
The committee notes the request of the Honorable Wominal for the adoption of the explanatory note as his sponsorship speech. All the rest of the manifestations in support of House Bill number 5171 are likewise noted by this committee. Now we proceed to House Bill number 4279. We recognize the Honorable Congressman John Attorney J.P. Padiernos.
Thank you, Madam Chair. Good morning to everyone from the Department of Justice and all our resource speakers present this morning. So, Madam Chair, distinguished members of the committee and esteemed resource persons, again, good morning. The Office of the Chief State Counsel is the government's primary legal counsel. It assists the Secretary of Justice in his role as Attorney General and provides legal opinions, resolves interagency disputes, acts on immigration and citizenship matters, and advises national government agencies on complex questions of law. Over the years, however, the role of the office has grown far beyond what was envisioned in the administrative code and the original laws that created the legal staff. State counsels now lead the country's work in international legal cooperation, including extradition, mutual legal assistance, and the transfer of sentenced persons. They represent Philippine treaty partners in court, review and negotiate treaties and free trade agreements, and provide legal support for major economic, diplomatic, and security matters. They also guide agencies in drafting, implementing rules and regulations, and prepare the department's comments on enrolled bills. Despite this greatly expanded mandate, state councils have not received the recognition, benefits, or career structure enjoyed by their counterparts in the National Prosecution Service, the Office of the Solicitor General, the Judiciary, or the Office of the Ombudsman. This has left the office undermanned and at risk of losing experienced lawyers who handle some of the most sensitive legal matters of the state. This measure corrects that imbalance. It strengthens the office, aligns the ranks and benefits of state councils with their parallel institutions, expands the organizational structure to reflect their present workload, and provides the support necessary to retain and develop highly skilled government lawyers. At its core, this bill recognizes a simple principle that lawyers who protect the legal interests of the government should receive fairness, stability, and support equal to those who serve in similar roles across our justice sector. For these reasons, I respectfully urge the swift passage of this measure so that the work of state councils, long overlooked, is finally matched with the recognition and parity that they rightly deserve. Thank you, Madam Chair.
The sponsorship speech of the Honorable Padiernos in support of House Bill 4279 is duly noted. And for our last legislative measure on the same matter, House Bill number 4376, we recognize the Honorable Congressman Rufus B. Rodriguez and the Honorable Congressman Maximo B. Rodriguez Jr. The Honorable Padiernos is recognized.
Madam Chair, may I move that the explanatory note for House Bill number 4376 by Representatives Rufus Rodriguez and Maximo Rodriguez Jr. Be adopted as their sponsorship speeches.
There is a motion to adopt the explanatory note of House Bill number 4376 as the sponsorship speeches of the Honorable Rufus Rodriguez and the Honorable Maximo B. Rodriguez Jr. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the said motion is hereby approved. The COMSEC is now directed to call on the resource persons from the concerned departments and agencies to give their respective comments and manifestations. COMSEC, please.
Thank you, Your Honor. From the Department of Justice, Chief State Counsel Dennis Arvin L. Chan.
Chief State Counsel Chan is recognized.
Good morning, Madam Chair, and to the honorable members of the committee. First of all, we would like to extend our sincere appreciation for hearing the 6 House bills that propose to strengthen the legal staff of the Department of Justice. And as the Honorable Madam Chair mentioned, this bill or the subject matter of this bill was extensively discussed before the Committee of Justice or Committee on Justice during the 19th Congress. And with that, we just have 3 manifestations, Madam Chair, if we will be allowed.
Definitely, Chief State Counsel Chan.
Thank you, Madam Chair. For Section 5, Your Honor, Madam Chair, and as manifested by the Honorable Congressman Uminal, if the appointments of the state councils, we request that the phrase, the appointments of the state council shall be deemed permanent upon compliance with the prescribed qualification standards under the law, be inserted. We note that this clause was also part of the approved Senate Bill number 2987 during the 19th Congress.
Can you please reiterate in which particular part the proposed phrase should be inserted? This is Section 5. Which paragraph?
For Section 5, Madam Chair, it will be the second to the last paragraph.
Second to the last paragraph. So, can you restate that, Chief State Counsel Chan? Second to the last paragraph. Should this be the last statement? No.
No, Your Honor.
It should be incorporated in the last paragraph.
Second to the last.
Second to the last
Yes.
paragraph. Okay. Last statement of the second to the last paragraph of Section 5. Is that correct? Last sentence of the second to the last paragraph.
Sorry, Madam Chair, for the confusion. For House Bill, okay. Okay. Sorry. Madam Chair, for the second to the last paragraph, it is requested that a new first sentence be inserted. So it will read, appointments of the state councils shall be deemed permanent upon compliance with the prescribed qualification standards under the law, and then followed by the phrase, the state councils occupying the positions affected by the changes in this act, until the word appointment.
All right. Please submit your proposed revision for this particular paragraph of Section 5 to the Committee Secretariat.
We will, Madam Chair.
For your next concern?
For Section 10, Madam Chair, with respect to survivorship benefits, on the provided further clause as appearing in the 3rd paragraph, for purposes of consistency, in line with the approved Senate Bill number 2987, and this also can be found in the NPS Act. We request that the word 1 year be inserted after the word retired.
May we know which particular paragraph of Section 10?
The 3rd paragraph, Madam Chair, beginning with provided further. It will read, provided further, that said benefits shall be granted to the surviving legitimate spouse or dependent of state councils who retired 1 year prior to the effectivity of this act.
Similar request to submit the proposed revision to the Committee Secretariat for the guidance of the committee members. These are manifestations coming from the Chief State Counsel, and we will be needing the necessary motion of the committee members for the adoption of these manifestations as amendments to our bill.
Thank you, Madam Chair. And then for our last manifestation or request, Madam Chair, with respect to Section 13 on other benefits and privileges. Again, for purposes of consistency and parity with our counterpart from the National Prosecution Service, if an additional subparagraph D, as in dog or delta, could be inserted, providing for an annual 30 days forfeitable leave with pay.
So in summary, Chief State Counsel, you have proposed amendments for Section 13, Section 10, and Section 5.
That is correct, Madam Chair.
Okay. So once again, for the guidance of our committee members, we will be needing the appropriate motion for the adoption of this request as amendments to our legislative measures. Are there any other comments or manifestations?
We have no more manifestations.
All right, COMSEC, may we call our next resource person?
From the Department of Foreign Affairs, Mr. Paulo V. Saret, Executive Director of the Office of the Treaties and Legal Affairs.
Thank you, Madam Chair, and to your honors and other resource speakers, good morning. Madam Chair, we just wish to manifest DFA's full support for the Office of the Chief State Counsel. As already mentioned, the OCSC is our partner not only in negotiating and crafting international agreements, because I belong to the Office of Treaties and Legal Affairs, but they are likewise our partner in the implementation and interpretation of such international agreements. Most notable, we are always together in negotiating and crafting extradition treaties, transfer of sentenced persons, Madam Chair, and MLAT, which is very important, Mutual Legal Assistance Treaty on Criminal Matters. And aside from that, of course, when negotiating economic treaties like free trade agreements, they are likewise our erstwhile partners. So again, our resounding support, Madam Chair, for the strengthening of this office, which has long deserved our wholehearted support. Thank you, Madam Chair.
We thank the Department of Foreign Affairs in supporting the legislative measure on the standardization and strengthening of the Office of the Chief State Counsel. Nonetheless, may we request the DFA to kindly put in writing, for purposes of reference of this committee and the other committees and offices who might be involved in the shepherding of this bill, kindly submit
Sure, Madam Chair.
your written support to this legislative measure at the soonest possible time.
Yes,
Thank
Madam
you.
Chair. Thank you, po.
Thank you. COMSEC, our next resource person.
From the Department of Budget and Management, Attorney Tennessee Ann L. Mengulio.
All right, state councils, listen.
Good morning again, Your Honors. First, on the proposal to rename the legal staff to Office of the Chief State Counsel, we interpose no objection, since the renaming will reflect in its nomenclature the functions and services of the office. However, we are constrained from recommending the upgrading of the state counsel positions, since the proposal will distort the hierarchy of existing positions therein, as the positions of the chief and deputy chief state counsels will be both allocated to the same salary grade, SG 30. Nevertheless, in case the Department of Justice will propose the creation of additional state counsel positions and support staff, the same shall be submitted to the Department of Budget and Management for evaluation and approval. With regard to the allocation,
If I may interrupt, just
Yes, you're-
not to cut the line of thought, no? Let us give opportunity to the state councils to address your comment, especially with respect to the distortion of salary grade. I understand that the Chief State Counsel has something to explain in order to satisfy your concern about that. So if I may
Yes,
interrupt,
Madam Chair.
DBM,
Yes, Madam Chair.
Chief State Counsel Chan, please.
Thank you, Madam Chair. Thank you to DBM for their full support in the change of our name. At the same time, Your Honor, if we could address the comment coming from the DBM rep as to the perceived distortion in salary grade. We would like to note that this is not a new concept, Your Honor. This started with Republic Act number 9406. I believe this is the law of the Public Attorney's Office, where the chief public attorney was given a salary grade of 30 step. So sorry, Madam Chair, the public attorney has a salary grade of 30, and then the deputies were given a salary grade of 29, step 4. At the same time, Madam Chair, for the National Prosecution Service, the Prosecutor General has a salary grade 30, step 8, increment for the prosecutor. And then for the next in rank below the Prosecutor General or the Senior Deputy State Prosecutors, they have a salary grade 30. So no step. So this is the proposed salary grade upgrading in the bill, Your Honor, has precedent and consistent with the position of parity with our counterpart from the prosecution service. We are just equalizing or adapting the current salary grade structure in the NPS. Thank you, Madam Chair.
The committee notes the answer of the Chief State Counsel with regards to the concern on the salary and salary grade distortion. The DBM may proceed with its comment and manifestation.
Thank you, Madam Chair. With regard to the increase in with regard to the retirement benefits of the state councils, we note that the proposal will increase the gap between the retirement benefits of employees of the executive branch and that of a select group of employees. This will promote inequity and may ultimately cause other lawyer positions in the DOJ and even in other agencies to request for the same treatment. Accordingly, this will translate to a significant fiscal impact. With regard to the additional benefit,
Before you proceed, would the Chief State Counsel willing to comment about the retirement benefits?
Thank you, Madam Chair. Similar with the salary grade increment, Your Honor, this is being enjoyed by our counterpart from the National Prosecution Service, and it is just consistent with the theme of parity among the lawyers within the Department of Justice proper.
So the committee notes again the answer of the Chief State Counsel. Meron na daw po nito ang mga piskal. Humahabol lang sila and be at par. The DBM may proceed.
thank you, Madam Chair. For the other benefits being proposed, first on health benefit, we note that the Commission on Audit has issued resolution number 2005-001 stating that the Philippine Health Insurance Corporation is already providing a health program in the government to improve the working conditions of employees. The said resolution further stipulates that the procurement of private health insurance by an agency or instrumentality of the government is an irregular expenditure and constitutes an unnecessary use of public funds. Moreover, thus, we note that the proposal will constitute double provision for the same benefits since the national government is already providing its employer share in the premium contributions of the health insurance of government employees.
Will the Chief State Counsel invoke the same parity principle?
For these benefits, Madam Chair, I will be adopting a different approach.
Please
and
proceed.
I will now cite, Your Honors, the fact that these HMO or this HMO benefit is currently being enjoyed by our friends from the Office of the Solicitor General and also from the National Bureau of Investigation. So while the comment observation of the DBM is acknowledged and recognized, there are other offices that are already enjoying this benefit.
The committee notes the response, the comment of the Chief State Counsel. DBM, please proceed.
Thank you, Madam Chair. As to the retroactivity provision in the proposed measure, we note that the proposal will result to a huge fiscal impact considering the benefits sought to be granted, such as the expansion, upgrading, and creation of positions, compensation and benefits, and automatic increase in pension benefits. In effect, these upgraded features and benefits are sought to be granted even to those who retired prior to the effectivity of the law. Equity and prudence dictate that allowing the proposal may not be considered as a judicious use of public funds.
The Chief State Counsel have any comment to that?
Madam Chair, upon a reading of the proposed House bills, we do not see any retroactivity clause except for the one appearing on Section 5. Sorry, Your Honor, Section 10 on the survivorship benefits that only
1 year
provides
prior.
that it will be applicable to the surviving legitimate spouse or dependent of state councils who retired 1 year prior to the activity of this act. So save for this particular benefit, Your Honor, there will be no retroactivity of the benefits and privileges provided in this House, in the House bills, Your Honor.
The committee takes note of the comment of the Chief State Counsel on the retroactivity concern of the DBM. Any other comment, DBM?
Yes, Madam Chair. Lastly, the proposal on the establishment of a trust fund for the collection of fees for the office's services. We note that this violates the one fund concept in government budgeting. The policy provides that all fees, charges, assessments, and other receipts or revenues collected by departments, bureaus, offices, and instrumentalities of the national government shall be deposited with the National Treasury as income of the general fund. Income should form part of the revenue and financing sources of the national government for its expenditures, which is subject to the budgeting process and authorized under the General Appropriations Law. In this regard, we are not recommending the establishment of the proposed trust fund. Madam Chair, thank you.
Comment from the Chief State Counsel on the creation of ITF fund, which the DBM opposes.
Your Honor, we believe that the purpose behind this trust fund, Your Honor, is to fund the benefits that the state councils will be enjoying. At the same time, there are certain services that the legal staff or the Office of the Chief State Counsel renders for which there is a corresponding fee. And so the collection of these fees will be used to defer some of these charges, some of these benefits, Madam Chair. But ultimately, we defer to the wisdom of the Honorable Congress on whether to adopt the one fund, one policy approach. But at the same time, we note that there are already other offices that have their own separate fund and not just taken from one pocket of the government. Thank you, Your Honor.
The committee takes note of the comment of the Chief State Counsel on the issue of the creation of trust fund of the Office of the Chief State Counsel. We thank the DBM for ventilating all their comments or opposition or support, at least to the first item, to the proposed legislative measure. I understand that most of the concerns of the DBM pertains to the budgetary requirements, which will be amply discussed on the Committee on Appropriations. So we defer to resolve the issues of budgetary requirements and all other financial concerns relative to this bill. Nonetheless, we allow the Chief State Counsel to give their comment for reference of the committee and the subsequent committees who will be hearing the similar bills. COMSEC, may we call our next resource person?
From the Office of the Solicitor General, Assistant Solicitor General George O. Orto II.
Good morning, Your Honors, and good morning to all the members of the committee, as well as our fellow public servants. In general, Your Honors, the OSG fully supports the strengthening of the legal staff and the granting of whatever benefits. Of course, we defer that to the better judgment of the DBM, Your Honors. May we just ask some clarifications, Your Honor? For instance, in Section 4 on the powers, paragraph J, because it says here, Your Honor, to adjudicate disputes, claims, etc. This is traditionally under the power of the Secretary of Justice, but here it specifically mentioned adjudicate. So as earlier conveyed with our colleagues, is the intention here to transfer the power from the SOJ to the Office of the Chief State Counsel, Your Honor? Or this is just as what is being practiced right now? They just do the work, but ultimately you submit it to the Secretary of Justice. So it's more of a review, recommendations, but the ultimate decision is with the Secretary of Justice. So that's one clarification, Your Honor. But still in paragraph, Section 4, paragraph J, Your Honor, there's a mention here. This really pertains to PD 242 traditionally, but they mention here when only questions of law are raised. Under the Executive Order 292 or the Admin Code, as well as the 2015 Uniform Rules of Procedure, the jurisdiction of the DOJ is when the dispute is between a national government agency and a GOCC, or if the question is purely question of law, Your Honor. So, but here it's being limited only to pure question of law. So just again, a clarification, if we are going to amend the Admin Code or PD 242, which was adopted in the Admin Code and which is actually written in the Uniform Rules promulgated by the DOJ in 2015. Next, Your Honor, is...
Before you proceed, OSG, let us hear from the Chief State Counsel about the seeming modification of the power of the Office of the Chief State Counsel with regards to adjudication.
Thank you, Madam Chair, and to ASG Ortha for that observation. Your Honor, we apologize that the wording of subparagraph J under Section 4 may have created that confusion. But the intent is merely to to formalize the current practice within the office, and that is the state councils will hear and adjudicate the issues presented to it for arbitration, but ultimately the signing authority will still be the Secretary of Justice. And as to the perceived limitation of the issues to be heard or resolved by PD 242, we will adopt what is worded under the Admin Code of 1987 and the current uniform rules on PD 242 that is being implemented by the Department of Justice. Your Honor.
Thank you, Your Honor.
Does that satisfy the OSG?
Yes, Your Honor. Just Thank you
Okay.
for the clarification.
So the committee takes note of the comment and the answer of the Chief State Counsel.
Yes,
The
Your
comment of the
Honor.
OSG and the answer of the Chief State Counsel.
So I understand, Your Honor, even for paragraphs I and K, when the word used here is review, the intention is still for the office to do the actual work, but just submit it to
It
the
will be the
secretary
SOJ.
for the
Yes.
for its approval, Your Honor.
Yes.
Thank you for the clarification, Your Honor. Under section 4L4, in section 4L, Your Honor, it says here, act on applications. And there are 4 enumerated functions. I acknowledge, Your Honor, that 1, 2, and 3, these are usually, well, as by practice, Your Honor, it has been delegated to the Chief State Counsel. But number 4, regarding Baguio validation, while again the office does the work, it's again submitted to the Secretary of Justice for his approval. Unlike 1, 2, and 3, Your Honor, the designing authority is already delegated to the Chief State Counsel. So again, a clarification, Your Honor, whether number 4 there regarding validation of land titles or the Baguio validation is another matter to be acted on by the Office of the Chief State Counsel, or is it still going to be submitted to the Secretary of Justice? Because there is a committee, Your Honor, DOJ, well, the Secretary of Justice, the Solicitor General, and I think the LMB. They are the signatories, Your Honor.
Is it correct to say that you exercise the actual function you recommend, but it's actually the SOJ who has the final say?
Correct, Your Honor.
And that is the same with regards to number 4 of subparagraph L.
That is correct,
Right.
Madam Chair. So the function of actually validating the land titles will not be taken over by the Office of the Chief State Counsel. We will merely be performing a review function and recommendatory to the Secretary of Justice, as is the current practice.
Okay, so the committee takes note of the observation and the comment?
Yes,
OSG?
as currently worded, Your Honor, it says here, act on. And as practice, Your Honor, I think I mentioned earlier, let's say for 47A2 visa, this does not go anymore to the Secretary of Justice, Your Honor. The Chief State Counsel signs this. The same goes with number 2 and number 3. So for the authority to employ under the anti-dummy law and recognition of refugees' statelessness status, they don't go anymore to the Secretary of Justice. It's the Chief State Counsel that signs 1, 2, and 3. That's why I clarified. What happens to number 4? Do we put it under letter L as a number 4, or do we move it to another paragraph, something, Your Honor?
Yeah.
Okay. Thank you, Your Honor.
Response?
Yes, Madam Chair, thank you very much. We note that the validation of Baguio land titles is a power reserved exclusively for the Secretary of Justice. We observe that there is a subparagraph B that mentions study and recommend to the Secretary of Justice the following, and there is an enumeration of activities or tasks. We are proposing that L subparagraph 4 together with subparagraph J could be inserted in that subparagraph B, becoming its new subparagraph B 3 and 4 as matters that will be reviewed and recommended to the Secretary of Justice for his or her eventual approval.
So the committee takes note of the proposed modifications under section 4, the powers and functions of the Office of the Chief State Counsel. We direct as well the Office of the Chief State Counsel to submit to the committee secretariat the proposed modifications to this particular provision of the legislative measure. May I suggest as well to the Office of the Chief State Counsel to be more accurate, to use more accurate phraseology and terminologies in order to address the concern and the observation of the OSG, because I think that is significant. We have to distinguish between those which can be exercised, actually, the powers which can be exercised by the Office of the Chief State Counsel, and those powers which are merely recommendatory on the part of the Office of the Chief State Counsel.
We will be mindful, Madam Chair, of the use of the proper phraseology.
Yes, Your
observation
Honor.
from OSG?
Yes, Your Honor. Regarding Section 10 survivorship benefits, I don't know if the confusion on retroactivity is because of this, Your Honor. I was also clarifying this earlier with our DOJ colleagues. Because even those who retired prior to the effectivity of the act, okay, their heirs may be entitled to survivorship benefits. The question of prospectivity or retroactivity, Your Honor, now is, for instance, Your Honor, a state council retired prior to the effectivity of the act, and that person also died prior to the effectivity of the act. Since the survivor is entitled to survivorship benefits, will the survivor be entitled to the benefits retroacting to the date of the death of the state council, or the survivorship benefits will only be counted from the effectivity of the law? So that's where the issue of retroactivity may arise, Your Honor. I don't know if that's the issue of DBM earlier, when they mentioned retroactivity, because I also asked that earlier to our DOJ colleagues. Although they said that it's going to be prospective, meaning even if the state council died prior to the effectivity of the act, the survivor can only claim for survivorship benefits starting on the when the law takes effect. So in that case, there is no retroactive effect. This is merely prospective, Your Honor. If I understand correctly the reply of the DOJ.
Yeah, may we know the intention of the DOJ about the survivorship benefits?
Your Honor, Section 10 on survivorship benefits, the general rule is that this is prospective in application. The only instance or exception when it has a retroactive effect will be if the state council concerned retired 1 year
Before.
prior to the effectivity of the act. So for those state councils that may have retired 2 years, 3 years, 5 years before
Not covered.
they will not be covered. Which is why, as an aside, Your Honor, we have 2 or 3 state councils that are ready to tender their retirement.
So it will depend
So
whether
once
this will
is
be approved.
Yes, Your Honor. If this is not yet approved, they will stay longer.
Does that answer the OSG?
May I clarify this, Your Honor?
Yes, please.
If a state council retires 1 year prior to the effectivity of the act, then that state council or the heirs
It's covered.
would be entitled to survivorship benefits. Let's say that state council died 5 months before the effectivity of the act. So it's covered, Your Honor. But what I'm trying to say is, can the heir, and let's say the spouse and the children, claim for survivorship benefits 5 months prior to the effectivity of the act? That's the question of retroactivity, Your Honor. Or since the law takes effect only now.
I don't think that will be possible, because what
Yes.
is significant here is it takes effect upon the approval of the law. So for all purposes of claims, they should happen after the approval of the law.
Yes, Your Honor. I think that's the intention, and that's the clarification that we are saying, so as to maybe assuade also the DBM that it will not retroactively
Yes.
apply, Your Honor. Because I think, well, I happened to chat with some Supreme Court personnel before when they were amending their law, Your Honor. I think that was the concern. That's why they have something like, this shall be prospective in application. Just two things, Your Honor. On Section 12, about prohibition on representation. So, in the first part, you cannot represent if ang kalaban po natin ay government. Pero doon po sa portion ng may criminal case po dito, or in any criminal case wherein an officer or employee of the government is accused. So may clarification there, Your Honor, is can a state council be prohibited from being a private prosecutor? So hindi po adverse yung kanyang position sa government.
Complainant.
Opo, parang pareho po sila kasi private prosecutor po siya, so hindi po siya adverse sa government. pero hindi po malinaw. Very, very general po yung nakalagay dito eh. So may prohibition to represent in any criminal case. Unlike po dun sa civil case, wherein the government is an adverse party. So, hindi mo po pwedeng kalabanin yung gobyerno. Doon sa criminal case, wala pong clarification. Ay, hindi po malinaw kung pwede ka bang private prosecutor. So, yun po yung isa kong clarification, Your Honor.
You are saying that the private individual is a co-complainant of the government office?
Opo, ito po kasi, Your Honor, kung retired ka na po, you cannot represent a position adverse to the government. That's general. Pero po, doon sa criminal case portion po dito, that I think is line 4, nakalagay lang po, in any criminal case wherein an officer or employee of the government is accused. So kung meron po tayong ididemanda na public officer, si retired state counsel, hindi po ba siya pwedeng maging private prosecutor? So in short, hindi po siya adverse sa position ng government. Pero sa lingwahe po ng Section 12, hindi ko po sigurado kung pwede po ba siya maging private prosecutor or hindi. Or ipapareho po ba natin siya doon sa civil case that the prohibition is only if your position is adverse to the government.
Chief State Counsel?
Your Honor, that is the observation is correct that the prohibition under Section 12 is to take a position that is adverse to the government. So, acting as a private prosecutor in a criminal case where the officer or employee of the government is an accused would not be considered a prohibition and would allow the retired state counsel to perform functions as a private prosecutor.
Thank you, Your Honor. Just one more thing, Your Honor. Hindi na po siya related dito.
Okay.
Yung napag-usapan lang po kanina about the salary grade. Ang pagkakalam ko po, ang Prosecutor General, kapareho po siya ng Presiding Justice ng Court of Appeals. Ang Presiding Justice po ng Court of Appeals is SG 31. Pero hindi po ini-implement, kaya lang po binibigay sa PG yung SG 30 Step 8. Pero ang pagkakalam ko po, Your Honor, dapat 31 po siya.
The way I understand it, that step numbers are being adopted to avoid the distortion, which is the observation of the DBM.
Yes, Your Honor, but by law, the Prosecutor General is entitled to salary grade 31.
It's because the Secretary of Justice is SG 31. And it will be very difficult to conceive a situation where the SOJ and the Prosecutor General will be enjoying the same salary grade. I think that explains why the Prosecutor General is SG 30 Step 8 as distinguished from SOJ and the CA Justice, which are SG 31. To avoid
Thank you, Your Honor.
distortion. Thank you. Are you done with all your comments?
Yes, Your Honor.
Okay,
Again, we
thank-
want to express our support to
Thank
the
you. Similar
bills.
to our request to the DFA, we will be requesting for a written support of the Office of the Solicitor General. Again, this is for reference of this committee and the subsequent offices who will be taking part in the shepherding of this legislative measure.
Thank you, Your Honor.
Thank you. Next resource person, please.
From the Bureau of Correction, Deputy Director General for Administration, Assistant Secretary Al I. Pereras.
With the indulgence of our remaining resource persons for the Office of the Chief State Counsel strengthening of their office, we are requesting to shorten the manifestations in order to save some time for our third item, that is the creation of the court salas. The Bureau of Correction may proceed.
Yes, Your Honor. Good morning, Madam Chair, and to the distinguished members of this committee. Insofar as the Bureau of Corrections is concerned, we fully support the passage of these legislative measures, subject to for consideration by the committee, all the manifestations, insights of all the resource persons, Your Honor.
Thank you, Bucor, but we will be requesting also for your written support, again, for the reference of this committee and all other offices who will take part in shepherding the same.
Yes, Your Honor.
Maraming salamat po. Next resource person, please.
From the Bureau of Immigration, Attorney Emmanuel Anthony L. Vera Jr.
Yes, good morning, Madam Chair.
Good
Your
morning.
Honors. Good morning, co-resource persons. Yes, the Bureau of Immigration poses no objection. And as an attached agency of the Department of Justice, we fully support this bill. And we fully support the move to rename, to strengthen the legal staff of the Department of Justice, and also for its redefining, expanding, and rationalizing, and further professionalizing the organization. Thank you, Madam Chair.
Thank you, Bureau of Immigration. Similar request to submit a written support on this legislative measure.
Yes, Madam Chair.
Thank you.
Madam.
Next resource person.
From the Government Service Insurance System, Attorney Giovanni Lin Kikoy Marin.
Maayong buntag kanatong tanan. In behalf of our President, President Vic Veloso, we would like to thank the committee, the Honorable Chairperson, and mga kawani maayong buntag for inviting us. It is worth mentioning that the various House bills do not mention the participation of GSIS in the grant of these benefits, and the amount necessary for the implementation of the bills shall be charged against the Department of Justice and the Annual General Appropriations Act. As such, the proposed bills have no implication on the existing GSIS policies and have no significant impact on the GSIS fund like. Hence, we fully support the passage of the bills. And if we may share, as mentioned earlier, there is a question about hazard pay. Very briefly lang, Madam, if I may share.
Yes, you may proceed, ma'am.
We offer personal accident insurance. So those who are interested could...
GSIS is marketing their product.
And you could get it individually or as a group. Maybe DOJ will coordinate with our marketing department. Mayong udtos sa atong tanan. Thank you.
Thank you, GSIS. Ma'am, I will be making the same request to kindly submit to the Secretariat a written support to this legislative measure.
Yes, Madam. It's being
Thank you.
routed for signature. Thank you so much.
Thank you. And for our last resource person, the National Bureau of Investigation.
Thank you, Madam Chair. The National Bureau of Investigation fully supports the noble intention of the proposed bill.
I know
The
what's
proposed
in the
bills,
thoughts
rather-
of your attached agencies already.
Yes.
The parity principle.
And we
I
will
may
be
proceed.
submitting the official
So you are
written
supporting?
support. Yes, Madam Chair.
Okay, thank you. Kindly do submit the written support to this legislative measure. And last, of course, sorry, tinapos ko po yung under DOJ. Palusot pa, ano? The National Security Council.
Attorney Aisel D. Pangan from the National Security Council.
Good morning, Madam Chair, and to the members of this committee. During the 19th Congress, the National Security Council expressed its support to those bills aiming to rename the DOJ legal staff, and also expanding and further professionalizing its organization. For the 20th Congress, the National Security Council reiterates its support for the consolidation and passage of these bills covering similar subject. Thank you, Madam Chair.
Thank you, National Security Council. We will be making similar requests for the submission of written support to this legislative measure.
Yes po, Madam Chair.
Except for the DBM. Everybody supports. But of course, we understand the mandate of the Department of Budget and Management. Ma'am, rest assured that all your concerns will be amply deliberated upon when the bill is transmitted to the Committee on Appropriations, which is the proper committee which will hear all the financial concerns and the budgetary concerns. Nonetheless, we thank all the resource persons for giving their respective insights and comments to this legislative measure. The floor is now open for the questions of the committee members.
Madam Chair.
The Honorable Waminal is recognized.
Madam Chair, just a quick clarification to ASG Orta and to Chief State Counsel Chan. Pursuant to their discussion earlier on what's currently being practiced by the Office of the Chief State Counsel and the acts that are being delegated to it. So upon the comments of ASG Ortha, Chief State Counsel Chan conceded that several items in Section 4 be transferred to Section 4B to reflect the actual practice that it will be the Office of the Chief State Counsel will be doing the actual work subject to the approval of the DOJ. From Chief State Counsel Chan's response, it will be the following items that will be transferred to Section B, namely Section 4J and Section 4L, subsection 4. Yeah, but ASG Ortha, my apologies, sir, also pointed out that subsections I and subsections K on the review of the orders of the BI and the review of the tax ordinances are also being subjected to the approval of the DOJ. So my question is, should these subsections also be transferred to subsection B? Madam Chair.
Chief State Counsel, please respond.
Madam Chair, in line with the suggestion earlier to use the correct phraseology and to maintain consistency with what is the current practice within the office, we will have to recast some of the tasks here to reflect the current situation within the office. So there will be matters where the Office of the Legal Staff will be performing a review and recommendatory role. We will be indicating which of those will be in subparagraph B.
Correct.
And then for those that are not entirely, or it's a quasi-review only or quasi-recommendatory, it will be reflected in a different subparagraph to avoid a confusion and to correct any notions of overlap of authority with the Secretary of Justice. This will be embodied, Madam Chair, in the letter that we will be submitting to the committee for its appreciation.
Okay. Waminal?
Thank you, Madam Chair. That will suffice. We'll just wait for the Office of the Chief State Counsel's written position paper on the matter.
For the record, the Chief State Counsel is expected to submit the final version of the proposed modification of the concerned sections of this legislative measure. That is to address the ambiguities observed by the Office of the Solicitor General with respect to its recommendatory and its own power, respectively. Any other question or comment from the members? If there are no more questions, but I wish to acknowledge the presence of my Secretary General of Lakas CMD Party, the Honorable Joboy Aquino from the city of Butuan. Thank you, sir, for coming. If there are no more questions from the members, then we are done with the interpellation, and the chair is suspending the hearing. Pasuyo ako sa inyo.
Dumating lang ako.
We're done with the interpellation. The chair is now ready to hear the proper motion for consolidation, approval of the consolidated bills, and its corresponding committee reports subject to form and style. The Honorable Padiernos is recognized.
Madam Chair,
The Honorable Padiernos, please.
I move that for the consolidation and approval of House Bills number 2342, 3575, 3951, 4279, 4376, 5171, and the corresponding committee report subject to amendment, form, and style.
There is a motion for the approval of the aforementioned, there is a motion for the consolidation of the aforementioned bills, as well as for its approval, including its corresponding committee report, subject to form and style. But before I rule on this motion, Honorable Padiernos, I think we should take up first, welcome first the motion for amendment of the legislative measure with respect to Section 4, 10, 4, 5, 10, 4, 5, 13, and 15. Am I correct, Chief State Counsel?
Correct, Madam Chair.
Honorable Padiernos, can we move first for the adoption of these amendments to Section 4, 5, 13, and 15 as earlier manifested by the Chief State Counsel among its several manifestations?
Madam Chair, I move for the amendments as hereby discussed in this committee hearing for sections 4, 5, 13, and 14 to be adopted.
15.
13 and 15
All right.
as adopted.
There is a motion to amend Section 4, 5, 13, and 15. Do I hear a second? The same has been seconded. Is there any objection? The amendments, hearing none, the amendments to Section 4, 5, 13, and 15 of the current legislative measure is hereby approved. Now we proceed to the second motion. There is a pending motion for consolidation of the bills, approval of the consolidated bill, its corresponding committee report subject to form and style. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion for consolidation of legislative measures, the motion for its approval, including its committee report subject to form and style, is hereby approved as well. Congratulations to the Office of the Chief State Counsel.
Madam Chair.
The Honorable Padiernos is recognized.
Madam Chair, I move that the members present in today's hearing be also considered as co-authors of this bill.
There is a motion
Second.
for the inclusion of the present committee members among the co-authors of this bill. The same has been seconded. Do I hear any objection? Hearing none, the motion is likewise approved. Congratulations again to the Office of the Chief State Counsel. So, as a reminder, please be ready with the projection of your expenses as a consequence of this legislative measure and also your career plan intended for the lawyers and staff of the legal department. Make sure that you will be able to show numbers because the We now proceed to the last item in our agenda, which is the creation of which pertains to 5 bills creating new and additional courts across the country. Again, as author of House Bill 6133, I would like to manifest that I am adopting the explanatory note of House Bill 6133 as my sponsorship speech. COMSEC is directed to read the titles of the bills.
Thank you, Your Honor. House Bill number 2362, an act creating additional branches of the Regional Trial Court and the Municipal Trial Court in cities in the 5th Judicial Region to be stationed at the Municipality of Calabanga, Province of Camarines Sur, and the City of Naga, further amending for the purpose Batas Pambansa Bilang 129, otherwise known as the Judiciary Reorganization Act of 1980 as amended, and appropriating funds therefore, and House Bill number 5548, an act creating additional branches of the Regional Trial Court, the Family Court, the Municipal Trial Court in cities, and the Municipal Trial Court in the 5th Judicial Region to be stationed at the municipalities of Calabanga and Pili, as well as the City of Naga, Province of Camarines Sur, further amending for the purpose Batas Pambansa Bilang 129, otherwise known as the Judiciary Organization Act of 1980 as amended, and appropriating funds therefore, filed by Representative Nelson S. Legacion. House Bill number 3029, an act creating one additional branch of the Regional Trial Court in the 4th Judicial Region to be stationed in the Municipality of Infanta, Province of Quezon, and appropriating funds therefore, amending for the purpose Section 14E of Batas Pambansa Bilang 129, otherwise known as the Judiciary Reorganization Act of 1980, as amended, filed by Representative Wilfrido Mark Enverga. House Bill number 5565, an act creating 4 additional branches of the Municipal Trial Court in cities in the 11th Judicial Region to be stationed in General Santos City and appropriating funds therefore, amending for the purpose Section 29 of Batas Pambansa Bilang 129, otherwise known as the Judiciary Reorganization Act of 1980 as amended, filed by Representative Sherlyn L. Banyas Nograles. And finally, House Bill number 6133, an act creating one additional branch of the Regional Trial Court in the 4th Judicial Region to be stationed in the Municipality of San Pascual, and 2 additional branches of the Municipal Trial Court in the 4th Judicial Region to be stationed in the municipalities of Lobo and Tingloy, all in the province of Batangas, and appropriating funds therefore, amending for the purpose Sections 14E and 30 of Batas Pambansa Bilang 129, otherwise known as the Judiciary Organization Act of 1980 as amended, filed by Representative Attorney Jervil Jinky Beatrix R. Luistor. That will be all, Your Honor.
We will now proceed to the sponsorship speeches of the principal authors. For House Bill number 2362 and House Bill number 5548, we recognize the Honorable Congressman Nelson S. Legacion.
Thank you, Madam Chair. Magandang tanghali po sa ating lahat. Tanghali na po. May I request, Madam Chair, that the explanatory note for House Bill number 2362, as well as the explanatory note for House Bill number 5548, be adopted as my sponsorship speeches for the said 2 House bills.
There is a motion for the adoption of explanatory notes in House Bill number 2362 and 5548. Is there any second?
Second.
Is there any objection? Hearing none, the explanatory note for HB 2362 and 5548 are hereby adopted as the sponsorship speeches of the Honorable Nelson S. Legacion. Moving forward.
Further, Madam Chair, may I
Proceed,
be allowed?
Congressman.
Yes po. House Bill number 2362 seeks to create 3 additional courts, 2 RTCs, 1 MTCC, while House Bill number 5548 seeks to create 8 new and additional courts, 1 RTC, 2 family courts, 3 MTCCs, and 2 MTC. Now, the first proposed House bill was drafted and submitted to the House of Representatives after discussion with the executive judges in Naga City. But thereafter, the regional court manager for Bicol Region, Attorney Raisa Nicole Menjola Ladlad, requested an audience with this representation and correspondingly requested for the creation of 8 additional courts. This explains why there are 2 proposed House bill of this representation. Now, I have noted, Madam Chair, that the Office of the Court Administrator had submitted before this committee its comment and recommendation. And based on the subject recommendation, it appears that the Office of the Court Administrator is in favor of the proposed House Bill number 2362. However, insofar as House Bill number 5548, it only recommended for the creation of additional courts as follows: 2 family courts, 1 in Naga and 1 in Calabanga. Likewise, 2 MTCCs in the city of Naga and 1 MTC in Pili. In other words, for the total 11 courts which are being sought to be created under the 2 proposed House bills, the recommendation was only for a total of 8 courts, namely, for the city of Naga, covering the jurisdiction for the regional trial court, 1 RTC and 1 statutory family court. Also, 3 MTCCs. The first one is that one that was recommended for approval under House Bill number 2362, while the other 2, the proposed, supposedly 3 MTCCs, but the recommendation was only for 2. And therefore, a total of 3 MTCCs in Naga City. For Calabanga, 1 RTC and 1 statutory family court. And for the municipality of Pili, 1 MTC. Therefore, a total of 8 new and additional courts. Now, given this, Madam Chair, I am requesting that I be allowed to consolidate the 2 proposed bills, namely House Bill number 2362 and House Bill number 5548, to conform to the recommendation of the Office of the Court Administrator.
May we hear from the Deputy Court Administrator?
Good afternoon, Your Honors, and to Madam Chair and to the honorable members of the committee. As mentioned by the honorable representative from Kamsur, the Honorable Nelson Legacion, we are fully supportive of the consolidated bills for 2362 and 5548, as mentioned, to conform to our recommendation that instead of the total of 11 courts, it will be reduced to 8 courts but because we fully really support the creation of one RTC in Naga and one statutory court in Naga, and for Calabanga, since it is a single sala court, we really fully support another RTC in Calabanga that will declug the caseload of our single sala RTC, and one statutory FC in Calabanga, because we don't have any FC in Calabanga. And instead of one MTCC as proposed in 2362 and another 3 in 5548, so instead of 4, we are requesting just 3 MTCCs in Naga. And then for Pili, because of the manageable caseload, we only recommend 1 MTC per Pili. So we fully support the creation of the 8 new and additional courts in the Kamsur area, Your Honors.
Thank you to the Office of the Court Administrator. To the author, are we amenable to the suggestion?
Yes,
The
Mr.
consolidation.
Chairman. In fact, my request earlier is to allow me to consolidate the 2 House bills in order to reflect therein in the consolidated bill the recommendation of the Office of the Court Administrator.
Can we ask for a motion to reflect the same from the author?
I do not know if I am allowed, considering that I am not a member.
Madam Chair.
Yes, I believe that the Honorable Padiernos will be willing to move to address the concern of the Honorable Congressman.
Consolidation of the two bills.
Madam Chair, I move for the consolidation of the 2 bills to reflect the position of the Office of the Court Administrator.
There is a motion for consolidation of 2 bills to address the concern of the Office of the Court Administrator. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion for consolidation of these 2 bills is hereby approved.
Thank you, Madam Chair.
Now we are proceeding to congratulations, Congressman Legacion. He waited for so long. He came earlier than me. Palakpakan po natin si Cong Legacion. Kaya nga, di ba? Moving forward, we recognize the Honorable Congressman Wilfredo Mark M. Inverga
Madam Chair.
to sponsor House Bill 3029. The Honorable Legacion is recognized.
I was requested, and therefore, in the representation of Congressman Mark Inverga, I move that the explanatory note contained in House Bill number 3029 be adopted as his sponsorship speech.
There is a motion for the adoption of the sponsorship speech. The same has been seconded. Is there any objection? Hearing none. The explanatory note of HB 3029 is hereby adopted as the sponsorship speech of the Honorable Chair Mark Inverga. Moving forward, House Bill number 5565. We recognize the Honorable Congresswoman Sherlyn L. Bañas Nograles.
Thank you, Madam Chair. Madam Chair, I move that the explanatory note of House Bill 5565 be adopted as my sponsorship speech. And may I add also, Madam Chair, that in 1968, 3 city courts were created pursuant to the City Charter of General Santos City, Republic Act 5412. And later, with that time, our population is around 150,000. And later, with the enactment of BP 129, the city courts became MTCC. But the number is still the same. We have 3 MTCC branches. Now, 5 decades after, or 57 years after, we still have 3 branches up to this moment. And the population is already more or less 750,000. So the influx of these cases, despite the diligent efforts of our judges and court personnel, has really overwhelmed our judicial infrastructure. So I hope that this bill would merit the approval of this body. Thank you.
So there is a motion as well for the adoption of the explanatory note of HB 5565 as the explanatory note of the Honorable Banyas Nograles. Do I hear a second?
Second.
Is there any objection? Hearing none. The explanatory note of HB 5565 is hereby adopted as the sponsorship speech. The rest of the manifestation of the Honorable Congresswoman is hereby noted by the committee.
Thank you, Madam Chair.
We will be asking for comment and manifestation of the Office of the Court Administrator and the rest of the resource persons after all these sponsorship speeches. We will now proceed with the comment from our resource persons. Comsec, please.
Thank you, Your Honor. From the Supreme Court of the Philippines, Deputy Court Administrator, Honorable Lilian C. Baribalco.
Again, good afternoon, Your Honors, Madam Chair, and to the members. As for House Bill, allow me to state our comment briefly on the different bills.
This will be for the second bill, ma'am, because we are done with the first bill. Correct?
For 2362, Madam Chair. Okay.
2362 and 5548 were the ones which were consolidated earlier.
Yes, that's.
So this is House Bill 3029.
For 3029, for the one additional RTC to be stationed in Infanta, Quezon, because in Infanta, Quezon, we only have single sala RTC with a caseload at present, as of July, 960 cases. So we fully support the creation of one additional RTC to be stationed in Infanta, Quezon. For the next House Bill, Your Honors, Madam Chair, 5565, for the creation of 4 municipal trial court in cities in the General Santos City. Right now, we have 3 existing MTCCs in General Santos City, and as of July of 2025, we have, per our record, per court, an average caseload of 407 cases. So we recommend the creation of instead 2 additional MTCCs, because we just felt that this is the 2 MTCC will already be sufficient to meet the anticipated increase in the judicial demand in the MTCC of General Santos City. And for the House Bill 6133, in one RTC in San Pascual, Batangas. Right now, San Pascual is within the territorial jurisdiction of the Batangas City RTC, which has 7 regional trial courts and 1 family court statutory. And based on our record as of, again, July 2025, the Regional Trial Court of Batangas City has practically a manageable caseload of 190 cases per court. So, for now, we don't see the need for the San Pascual RTC. Although we are also considering, Madam Chair, that should there be a need to have another court, no, outside of Batangas City, we were just humbly suggesting if this honorable body would consider, instead of San Pascual, the honorable body or the Madam Chair as the proponent of this might reconsider Mabini instead of San Pascual because of the geographical location. Okay. That's only a humble suggestion, Your Honor.
The chair temporarily relinquishes the chairmanship to the Honorable Padianos. Meantime, I wish to commend to the observation of the Office of the Court Administrator. Batangas has a fast-growing economy. It is going through dramatic industrialization. And the seat of the Regional Trial Court is actually in Batangas City, which is described as the central business district of the province of Batangas. I wish to add that the international port is likewise situated in Batangas City. So, similar to the argument of the gentleman from Bataan, this representation is opting to become proactive rather than reactive. So in anticipation to the dramatic growth of population, which includes the possible cases which will be filed in court, we are really supporting, invoking the creation of the Regional Trial Court in San Pascual, Batangas. This representation acknowledges and appreciates, in fact, the suggestion that it be created instead in other municipalities like Mabini. But I wish to share with the committee that San Pascual is a little urbanized compared to the adjoining municipalities. So I believe that transportation-wise and accessibility-wise, having this regional court sala in the municipality of San Pascual compared to any other municipalities will be wiser and beneficial for the litigants and the other court employees. So finally, I wish to add that while there are regional trial courts which are operating already in other legislative districts, there are RTCs in Santo Tomas, RTCs in Tanawan, RTCs in Rosario, Lemery, Taal. I am not really familiar about the delineation of jurisdiction or venue with respect to the judicial region. But I wish to point out that while the other legislative districts have their regional trial courts with them already created and operating, I believe that it is only the 2nd district of the province of Batangas which does not have a regional trial court seating created in its own legislative territory. So with that, we really invoke and request the support of our committee members for the creation of the regional trial court in San Pascual, Batangas. And for now, I am very willing to hear the comment of the court administrator with respect to MTC Lubo and MTC Tingloy.
Thank you, Madam Chair, and thank you also for those information, because we recognize and we admit that whenever we submit our comment, we only base that per record of our office, and what is going on the grounds, the honorable members or proponent is in a better position. So the truth is, at the end of the day, we also defer to the recommendation, because you are in a better position to make the assessment and evaluation of the number of courts to be submitted or to be recommended. Okay, so that's our submission, Your Honor, Madam Chair, for the San Pascual. Although kasi nang nakita ho namin, baka lang na okay mas sa Mabini, pero if it is the recommendation of the chair, who happens to be the proponent of this bill, we submit to it, Your Honor. Okay, moving on for the MTC of Lobo and Tingloy. For now, the Lobo MTC of the municipality of Lobo is within the territorial jurisdiction of the Municipal Circuit Trial Court of Taysan and Lobo, wherein the seat is in Taysan. Right now, based on the records of the office, there are only, as of July 2025, the Municipal Circuit Trial Court of Taysan and Lobo has 20 cases. Although we don't have a record what are the cases that originate from Taysan and what are the cases originated from Lobo. Because when the cases are filed in court, it's just MCTC of Taysan and Lobo. Okay, so but right now the record of our office indicates that there are only 20 cases as of July 2025, and I don't know if our record is correct, Madam Chair and the other members, that the distance between Taysan and Lobo is about 18 kilometers and could be traveled for less than an hour. I don't know if that is a an accurate assessment by land. So if we are going to take consideration only of the caseload, no, of the caseload, right now we do not recommend to decircitize the MCTC of Taysan and Lubo, or instead, if there's really a need to hold a court proceeding in Lubo, we can, the Supreme Court or the Office of the Court Administrator could authorize our presiding judge in MCTC Taysan Lubo to conduct proceedings in the municipality of Lubo. Okay? So, similarly, Your Honors, Madam Chair, to the Mabini in Tingloy, there is no MTC Tingloy, yes, because it is circuitized with Municipal Circuit Trial Court in Mabini, in Tingloy, although we also recognize that Tingloy is coastal, so they need to travel by sea, going to the Mabini, MCTC, as the seat of the Circuit Court. Although, again, Your Honor, Madam Chair, based on our record, as of July 2025, there are only 3 cases filed in MCTC, Mabini and Mabini Tingloy. So for this decircitization, for now, the recommendation of the Office of the Court Administrator, based on our record, there appears no immediate need to decircitize our MCTCs, Madam Chair.
With the permission of the chair, this representation wishes to respond. With respect to the decircitization of MCTC, Taysan and Lubo, I understand that the travel is less than an hour and around 20 kilometers in distance. However, we're talking about a long, windy, rocky, and dark road. And if I may add, there are sightings of rebels in that area. So I wish to reiterate our earlier observations that it is not only the case load which is being considered in the creation of court sala, but also the challenges with respect to the transportation, most especially transferring the inmates, the detention prisoners, from the municipal jail to the court sala. So if this justification merit the understanding of the Office of the Court Administrator as well as my fellow committee members, then it is my humble request really that we support the creation of MTC Lubo and have it separated from the Municipal Trial Court of Taysan. With respect to Tingloy, not at all times that the ocean between Mabini and Tingloy is sailable. Oftentimes, it is not sailable. So, I used to appear in MTC Mabini, and I have experienced a lot of postponement of cases originating from Tingloy because they could not travel not only the detention prisoners, but even the litigants for civil cases because of the travel constraints. So, again, if the Office of the Court Administrator will consider this as a sufficient justification, then it is my humble submission that notwithstanding the caseload, the MTC Lubo MTC Tingloy should be created as well to save the litigants from the danger of traveling via sea during schedule of their hearings. Mr. Chair, the Office of the Court Administrator would like to make further comments.
Just a short comment again, Madam Chair. Again, we recognize those information which is not present on our records. So we will relay this to the court administrator, and perhaps we are going to submit another comment on on the creation of this courts under 6133 bill. We just, as an additional manifestation, Madam Chair, the honorable members, may we just also manifest that should there be should these courts be approved, the budgetary allocation, of course, not only for the personal services, the MOE, and the capital outlay be considered, but the allow us to manifest that we will really appreciate if the budgetary allocation for our halls of justice be also be included, because again, while we may have new courts, but if there are no halls of justice to house them, no, our courts cannot function. Another thing, Your Honor, if there is a need to have additional courts, new courts, the territorial jurisdiction be determined by the Supreme Court. Okay? And I think the Office of the Department of Justice also would agree to us that just like on our previous hearings, that we also would like to recommend that whenever courts are created, prosecutors and public attorneys be appointed to our courts. Okay. Your Honor, that will be all for the Office of the Court Administrator. Thank you very much. We really thank the committee for inviting us to participate in this hearing. Maraming salamat po.
Comsec, please call the next or the second resource person.
From the Department of Justice, Attorney Rosario Elena C. Laborte Cuevas.
Thank you, Mr. Chair, Madam Chair. Good afternoon. Good afternoon, Your Honors. For the Department of Justice, we interpose no objection on the proposed creation of courts in different areas of the country, acknowledging that it is within the power of the Congress to enact laws reorganizing the judiciary. We likewise defer to the wisdom of the Office of the Court Administrator as to which areas should be placed, the new courts would be placed. However, we would like to manifest that pursuant to Section 13 of Republic Act number 10071, or the Prosecution Service Act of 2010, it provides that whenever new courts are created, there shall be an automatic creation of positions for assistant and associate prosecutors in the province or city where such new courts are created, in such number determined pursuant to the ratio established, which is 2 prosecutors for each branch of RTC and 1 prosecutor for each branch of MTC or MTCC, and 1 prosecutor for every 2 municipal trial court in municipalities and municipal circuit trial courts. That's all, Madam Chair. Thank you very much.
This is well noted. Comsec, please call the next resource person.
From the Public Attorney's Office, Attorney Noliver F. Barido.
Good afternoon, Mr. Chair, Madam Chair. The Public Attorney's Office fully supports these proposed legislations which aim to create new and additional courts. This would really help us in addressing the problem on court congestion and speedy disposition of cases. However, similar to the manifestation of the OCA and the NAPROS, we would like to request the amendments of these bills in order to be in line with Section 7 of RA 9406, or the PAO law, which states that there shall be a corresponding number of public attorneys at a ratio of 1 public attorney per 1 organized sala. That would be all, Madam Chair. Thank you.
Thank you. Last resource person with Comsec.
From the Department of Budget and Management, Attorney Tennessee Ann L. Mengulio.
Thank you, Mr. Chair. We just want to manifest that all requests for modifications in the organization and staffing pattern of the Supreme Court shall be submitted to the Department of Budget and Management for review and approval. And with regard to the number of prosecutors and public attorneys in the court salas to be created, the same shall be based on the prescribed ratio under RA 10071 and 9406, respectively. Thank you, Mr. Chair.
Thank you to DBM. Okay.
The chair reassumes the chairmanship. Thank you, Congressman Padiernos. We are done with the comment manifestation of the resource persons, so we will be opening the floor for interpellations. Are there any members who wish to raise questions to our resource persons or to the authors?
Madam Chair, just a clarification.
The Honorable Nograles is recognized.
Madam Chair, the suggestion by the OJ and PAU's office, shall we integrate it in the bill?
Yes,
In the
we will
amendments
be
later on?
welcoming a motion to amend the legislative measures so as to include the creation of the plantilla position, one prosecutor, one public attorney for every court sala created.
And then another thing also, Madam Chair, with respect to the comment of our court administrator, the amendment to reduce it to 2 instead of 4. While there are actually 416 active cases per branches of the moment, I was informed na talagang masisipag po ang aming judges doon sa Jensen that they are able to dispose a lot of cases monthly, that they are able to peg it at 400 lang. But, you know, the influx of cases are really quite a number. It's quite a number. But nevertheless, I am amenable that this be amended from 4 to 2. Thank you.
Can we hear a motion pertaining to the reduction of the court sala?
Madam Chair, may I move for the amendment of House Bill number 5565 to reflect the earlier recommendation by the Office of the Court Administrator from 4 MTCC to 2 MTCC in General Santos City.
There is a motion for the reduction of the court sala in HB number 5565. Is there a second?
Second.
Is there any objection? Hearing none, the same is hereby granted. With respect to the creation of one plantilla position for prosecutor and one plantilla position for the public attorney for every court sala created, may we hear the proper motion for amendment of these legislative measures? The Honorable Padiernos.
Madam Chair, may I move for the amendment of House Bills number 2362, 5548, 3029, 5565, 6133 to reflect the additional corresponding or creation of plantilla positions for the prosecutor and the public attorney's office.
There is a motion for the creation of plantilla position for prosecutor and for public attorney for every court sala created pertaining to House Bills number, so the aforementioned House Bills 6133, 2362, 5548, 3029, and 5565. Do I hear a second? The same has been seconded. Is there any objection? The proposed amendment is hereby approved. The committee is now ready to hear the motion for the omnibus approval of the legislative measures, including its committee report, subject to form and style.
Madam
with
Chair,
amendments.
may I move for the approval of the bills creating new and additional courts, as well as the amendments of House Bills number 2362, 5548, 3029, 5565, 6133, and then the corresponding committee report, subject to form and style.
There is an omnibus motion for the approval of the legislative measures with amendments, including its committee report, subject to form and style. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the same motion is hereby approved. Now, our favorite motion.
Madam Chair, since
It's past 12.
time to eat. Madam Chair, I move to adjourn our committee hearing.
There's a motion to adjourn. Definitely, Congresswoman Nograles is seconding. and objection is prohibited. The hearing is hereby adjourned. Thank you to all our resource persons. Please join us for our last official photo.